If you ever heard a probate horror story, months of court dates, a stranger showing up at the courthouse to outbid the buyer who thought they'd already bought the house, you might assume that's just how it works when someone passes away and leaves behind a home. In California and in many states, it doesn't have to be that way. If the home was held in a trust, the process can look almost nothing like that. And most people, including a lot of trustees who are going through this for the first time, don't actually know the difference until they've already found themselves in the middle of it. I'm Julia Romero Peter with Keller Williams. I'm a realtor and I'm also an attorney. And today I will break down how to avoid a probate horror story with a trust. I will go over how a trust sale actually works in California, what a successor trustee can and cannot do, what the law requires you to tell beneficiaries, and what you have to disclose to a buyer, and how that whole timeline compares to probate. Today I will make the practical side clearer and not rush you through it. Let's start with the basic distinction, because this is the piece that confuses people most. When someone dies owning a home in their own name with no trust, that property generally has to go through probate. This is so even if you have a will. If there is a will, a probate court admits the will to probate and validates it. Then the person named in the will is appointed as executor to administer the estate and distribute the assets in accordance with the will. Thereafter, the court process includes letters testamentary, which are issued, inventory and appraisal, credit notice period, final accounting, and court approval of distribution. If a person dies without a will, this is called intestate. When this happens, the probate court appoints an administrator and the assets are distributed according to California interstate succession statute. The court appoints someone, usually called a personal representative, to manage the assets of the estate, And depending on the powers that person is granted, selling the home may require a judge's approval and a public hearing where other buyers can show up and outbid the accepted offer. That's the process people mean when they talk about probate horror stories. It can take anywhere from 6 months to well over a year. A trust sale is a completely different animal. If the home was placed into a revocable living trust before the owner passed away, that person named as successor trustee already has the legal authority to sell it, spelled out right there in the trust document. No judge, no public hearing, no strangers walking in to outbid your buyer at the courthouse. In most cases, a trust sale can move through escrow in 30 to 45 days, essentially the same timeline as a normal home sale. This is the entire point of a living trust as an estate planning tool. It lets your family skip the court process entirely. But having the authority to sell doesn't mean a trustee can do whatever they want. This is the part that surprises people. A successor trustee has what's called a fiduciary duty to the beneficiaries of the trust. That means you're legally required to act in the best interest, get a fair price for the property, and manage the sale honestly, not just quickly. If a trustee sells a house to a friend at a discount or drags their feet in a way that costs the beneficiaries money, that trustee can be held personally liable. This isn't a technicality. It is the legal backbone of the entire trust sale process. And it's exactly why families sometimes bring an attorney alongside their real estate agent especially when there's more than one beneficiary involved. Before you can even list the property, there is a deadline most new trustees have never heard of. Under California Probate Court Section 16061.7, once a revocable trust becomes irrevocable, which usually happens the moment the person who created it passes away, the successor trustee has 60 days to send formal notice to every beneficiary and every legal heir. Every heir, not just the people named in the trust, even someone who was left out entirely, has to be notified because the law assumes they might want to challenge it. That notice has to tell them that the trust exists, who the trustee is, and that they have a right to request a full copy of the trust documents. It also starts a clock. Recipients generally have 120 days from that notice or 60 days from the actually receiving a copy of the trust, if that comes later, to bring a legal challenge. That's the part that should make every trustee pay attention. If you skip this notice or send it late or leave someone off the list, the contest window doesn't just get extended. In some cases, it can stay open indefinitely. A dispute that should have been closed after 4 months can resurface years later. This single 60-day deadline is, in my experience, the most overlooked step in the entire process. And it should happen before you ever put a sign in the yard. Now let's talk about what you actually have to tell a buyer, because this is another piece or another place trust sales work differently than people expect. Under California Civil Code Section 1102.2, sales handled by a trustee during the administration of a trust are generally exempt from filling out the standard disclosure statement form that most California home sellers are required to complete. The reasoning makes sense. A trustee usually never lived in the house and often has no personal knowledge of its condition. So the law doesn't require them to fill out a form describing things they have no way of knowing. But there's an important exception, and it's one I see missed constantly. If the trustee is a former owner of the property or lived in it at any point in the year before the sale, that exemption disappears and the full disclosure form is required after all. And even when the exception does not apply, being exempt from the form does not mean, or is not the same thing as being allowed to hide something. If a trustee actually knows about a real problem, a leaking roof, a foundation issue, anything that would matter to a buyer, that has to be disclosed regardless of which form is or isn't required. The exception covers paperwork you may not have the knowledge to fill out. It has never covered lying by omission. So here's how this typically plays out for a family in Contra Costa or anywhere in California. Someone passes away and their adult child is named successor trustee in the living trust. Within the first 60 days before anything else happens, the trustee needs to send the required notice to every beneficiary and heir. In parallel, the trustee gathers what's called a certificate of trust, a document governed by California Probate Court Section 18100.5, essentially proof to the title companies and escrow that they actually have the legal authority to sign on the property's behalf. Once that is in place, listing the home looks exactly like a normal. Where it gets complicated is when there's more than one beneficiary and they don't agree. Maybe one simply wants to sell right away and another wants to keep the house in the family. Maybe there's a dispute about whether the price the trustee accepted was actually fair market value. This is exactly where the fiduciary duty piece matters most, and exactly where having both a real estate agent and an attorney's perspective in the same room saves a family real time and real conflict. If you take one thing away from this video, let it be this: a trust sale is genuinely faster and more private and less expensive than probate. And that's exactly why your parents or your grandparents may have set one up in the first place. But faster doesn't mean informal. The 60-day notice deadline is real, the fiduciary duty is real, and personally enforceable or personal liability really is very real as well. The disclosure exemption has real limits, and getting these pieces right at the start is what keeps a trust from turning into the very probate style dispute a trust was designed to avoid. If you're a successor trustee in California trying to figure out what comes next, comment the word sell below and I can walk you through both sides at once, getting the property ready, sold, and making sure that the legal requirements along the way are actually met.